Hello everybody who has joined us. So this webinar is again brought to you as part of ClientEarth's joint project with Justice and Environment on the topic of access to justice for a greener Europe. It's funded by the EU's LIFE programme. So I'm Friel and I'll be giving you this webinar with my colleague Sebastian and Bechtel. We're both lawyers at ClientEarth who work on environmental democracy. So as many of you probably know, this is our third and final webinar on the topic of access to justice in the context of requests for environmental information. The last two webinars looked very much at the substance of the law surrounding the public's rights when it comes to accessing environmental information and challenging refusals. But this time we're going to focus much more on the practicalities of requesting and challenging refusals to grant access. So less on the law and much more on procedure and examples of good and bad practice. Right, so as I said, these are the links to our previous webinars that really contain much more, they're much more legal in general, and really more this kind of substantive arguments that you bring in a challenge. And today, as I said, we're really focusing on the practice. And we're going to run through the following things. So kind of what to think about before you make a request for access to environmental information, some do's and don'ts when you're drafting the request, then submitting requests, deciding whether to challenge the refusal in a confirmatory application, which is basically an application for the institution who refused your access to reconsider its decision, how to draft the confirmatory application, or at least some kind of do's and don'ts, and finally, how to make that decision on whether to challenge the confirmatory decision before the Court of Justice of the EU or the EU Ombudsman. I forgot to maybe mention that in the last webinars we looked at access to information both at EU level and at national level, and in this webinar we're really focusing on requesting information from EU institutions and bodies, so not so much about the national level. Okay, so first of all, these are kind of the things to think about before you go ahead and submit your request for access to environmental information. So because we're focusing on the EU level, the same procedure applies to whether you're requesting access to environmental information or to any other documents of the EU institutions. But if you want to rely on your added kind of Aarhus rights, or the kind of higher threshold of transparency when it comes to environmental information, you have to first of all make sure that the information that you're requesting comes within the definition of environmental information, which you will find in Regulation 1367/2006. And if it does come within that definition, you should point that out in your request so that you know that the EU institutions are going to apply your Aarhus rights when they're dealing with your request. So in the previous webinars, we talked in a bit more detail about what is environmental information. I'm not going to repeat myself here, and I'll let you listen to those webinars. So the other thing to think about before you actually submit a request is the information already publicly available somewhere? And one very handy way of checking that is using the institution's documents registers. So here I've just done a screenshot of the Council's documents register. And there's a number of different ways of checking the register to see whether the information that you want is actually out there already and publicly available. Sometimes the registers are not easy to search if you don't kind of know well how the EU institutions function. They usually only contain sort of official documents, so they don't generally contain emails, and sometimes, for example, the meeting minutes that you get are the ones that are drawn up specifically for the public, so they don't really contain very much information. Whereas if you do a request, you might be able to get kind of the meeting minutes that are taken for the benefit of the other officials working in institutions. So that's just something to keep in mind. So I've kind of gathered the links to some of the kind of very pertinent registers, documents registers. So for the Council, the Commission, the Parliament, and the European Investment Bank. There are some others out there for some other EU bodies and agencies, authorities, etc. But not all of them do have one. So the next thing you do, if you don't find the information is publicly available, is you have to formulate your request. So my first piece of advice is to make as few requests as possible. So for example, if you are not sure which institution holds the information you want, I would pick the one that you think is the most likely to do so. It's only really if you think that institutions will have different information on a specific topic that you should kind of send the same request to different institutions. It's important to keep in mind that the officials working in institutions are public servants. They are paid with our public money, so we don't want to waste their time. So the other thing is probably to make as few requests as possible. So if there's different information that you want, I would gather them all into one request and send it, rather than sending lots of different requests. This also means that it's much easier for you to kind of keep track of your own requests as well. And I think it's easier for the officials dealing with them as well. So the next thing is to try to make your request as precise as possible. So sometimes through using the documents registers that I just talked about, you can actually find the document that you want. You know that it exists, but you can't actually have access to it through the register. And then you can just, when you do your request, you can really use the institution's own reference number, and you can make the request extremely precise in that way. That's not always possible. One of the main problems that we have is that we just simply, we want to know something, but we don't know if the information exists, or we don't know who holds it, or in what form it comes in, and that can be then a bit more difficult to formulate your access to documents request. So the first thing you should do in that situation is really kind of distill in your mind exactly what you want to know and why, and that will really help you to draft the request in such a way that it's not just completely wide open, and that it could, for example, catch within its scope hundreds and hundreds of different documents spanning over a huge time frame. So these are just some tips on how to make an open request as precise as possible. So the first thing you can do is you can narrow it down in terms of the kind of form of information that you want. So if you know that what you're really looking for is an email exchange or an exchange of letters between specific people, you can make that clear in your request. The same, you might want meetings of a specific minutes of a specific meeting, or to know what was said in specific meetings, or by a kind of specific committee, for example. You might know that you want to have information to the notifications that a member state has sent to the Commission on a particular subject, or to a member state application for derogations from a legal obligation, or you might want the legal advice that's been sent from the Commission's legal service to its services, etc. So these are all kind of really useful ways of making the request a little bit narrower than it otherwise would be. That's the same, you can do the same thing with the content. So you might know that what you're really after is the member states or an institution's position on a certain topic, what the position they're defending on a question. Or you might want the lobby position of a certain company that's been sent to an official, or information on commissioners' expenses, etc., etc. You can also narrow it down by referencing a specific decision-making process or procedure. So you might know that you want to know how they came to a specific decision on regulation, blah 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 blah. That can also be very helpful. And then there's the time span. So you might know that you're really not interested in historic information, that you really want what's been said in the last year or the last 2 years on a specific subject. And you can make that clear in your request as well. And then finally, you can look at the actors or authors that you're interested in. So you might want correspondence between specific people or a specific rank of official, like, so for example, email exchange between head of unit or above in the commission with a specific lobbying company. So these are all ways of making what would otherwise be a really open request a bit narrower, and that really helps the officials that are dealing with your request, and it also means that there's more likelihood that you will receive a response within the deadline as well. So I've just put together some examples of information requests that we have submitted to give you an idea of what I'm talking about there. So the first one is a positive example, and it covers quite a range of the things that I've just spoken about there. So first of all, this was information we wanted to know the member state positions that they were defending in the decision-making procedure leading to the adoption of fisheries tax and quotas. So I checked the Council's document register to see what information was already publicly available, and I saw that there was quite a lot of interesting documents that had been circulated among the member state delegations in the Council, but they weren't actually publicly available. So I couldn't, while I could see that these documents exist, I couldn't click on them and actually download them and have access to them. But then I could use that in my access to documents request to really specify exactly what documents I did want to see using the Council's own references, etc. So that made their job a lot easier. However, I also know that the Council's document register is not always completely up to date, or that some of the documents that are relevant have not been tagged with the right information so that it shows up on the search that I was doing. So I added kind of a catch-all paragraph in the request, but that was still quite specific. So I showed them that I wanted access to any other document, but which recorded the position of the member states, because that's really what I was interested in, and then also in relation to a specific decision-making procedure, which I put down there as well. So that's kind of an example of asking for information that I didn't know if it exists, or I don't know what's out there, but I tried to make it as precise as possible. And the next two examples, just for balance, because that's such a good one, are two negative ones. This first one is an example of where I used the word or instead of the word and it brought me a whole lot of trouble later on at the confirmatory stage. So this was a case where we wanted to have access to a catalogue of nanomaterials and cosmetics that the Commission was meant to have published a few years before we made the request. So we didn't know whether the catalogue existed or at what stage of completion it was at. So we thought, well, if we can't see the catalogue, we'd really like to have access at least to the notifications which contain the information that the Commission is using to compile the catalogue. So therefore, we drafted the request, and we wrote, we'll see the catalogue or the notifications. At some point, I think probably in the confirmatory stage, the catalogue was actually published by the Commission. And so they said, well, now the catalogue is available for you to see. So this part of the second part of your request that asks for the notifications just falls away. It's not relevant anymore. But in actual fact, when we saw the catalogue, we realised that we really needed to see the notifications because the catalogue didn't contain all of the information they expected it would. So therefore we went, I had to have a bit of a battle to get the notifications, and that could have been completely avoided if I'd just written and instead of or. This is another kind of example of a learning experience. In this access to documents request, I wanted to have access to kind of basic information on what EU pilot procedures were opened against which member state. So I know that this information, I wasn't going to get very extensive information on pilot procedures because they're covered by a general presumption of confidentiality. I just wanted to know, like we know for infringement procedures, which ones were ongoing and against what member states. But the way in which I drafted the request, which asked whether there are ongoing pilot cases or infringement procedures, meant that when the Commission replied, they simply said, you want to know whether there are any ongoing pilot cases? Well, yes, there are. And full stop, that was it. So then at the confirmation stage, I had to clarify that that wasn't really my intention, etc. And that could have been easily avoided. So watch out how you formulate them and make sure that the wording reflects what you really want to know. So once you've kind of drafted your request, you have to submit it then. So first of all, I just wanted to make sure that everyone is aware of this fantastic platform that is administered by Access Info Europe, which is an NGO based in Madrid. They realised that actually just submitting an access to documents request already can actually be very difficult for many EU citizens, because it's difficult to find out which institution you really want to send it to, then find the right email address or the electronic form, etc. And all of this can actually really work to turn people away from submitting a very simple access to documents request. So they created this platform, which I recommend in some cases. I'll tell you, it's very useful because of these for these reasons. That first of all, it provides you with prompts for which institution, body, or department you want to submit to. So, for example, you can use the search engine to find out which institutions or departments exist and which is the relevant one for you. It tells you a bit about what they do and what their responsibility is, so then you can make sure that you're sending it to the right people. This means that it saves you quite a lot of time in terms of doing that research for yourself. It sends you notifications when a response has been received, so you kind of don't have to keep track of that by yourself. You can rely on the fact you're going to receive an email when you get a response. It also sends notifications when it also calculates the deadlines for you, which can be really useful. But what's great is that other interested parties can follow your requests, and then they can have access to the information at the same time that you do. So it all automatically becomes really publicly available, and that is actually published on our website when you receive information. And finally, if you do a lot of access to documents requests, this can be it's almost like a filing system for you. It's really easy to keep track of all of the requests that you're making, and then to go back to them whenever you need to. There are a few drawbacks to this platform, which are probably more relevant for lawyers and when you're thinking of challenging decisions. So the first thing is actually this first one isn't very relevant to me, but it could be to some other people, and that there's always a permanent public record of all the requests that you've made, and that turns some people away. They don't like the idea of that. But the ones that are more pertinent to my work are that there can sometimes be a delay, even just a few days, when the request is transmitted to the relevant institution, and that makes calculating the deadlines a little bit less reliable and a little bit complicated sometimes. And that's really relevant when you're thinking of doing a court challenge, because their deadlines really matter, and if you miss your court deadline because of just a delay in notification, that can be quite frustrating. But you don't have to use that platform. You can submit requests directly to the institution concerned. So as I said, sometimes it's a wee bit, unless you know the institution's websites quite well, it can be quite tricky to find where to send it to. And generally the institutions provide electronic forms for access to documents now, or postal addresses, and they don't tend to provide an email address, which I would prefer to just send it directly to a specific email address. Then I'm kind of know that it's definitely being picked up, and that I also have an automatic record of it in my sent items. Here is an example of electronic form. This is the Council's electronic form. Unfortunately, it doesn't show all of the extensive information that they ask for before you can submit a request. Like, they also ask for your postal address, which is probably not very necessary in this time of electronic communication. There you go. So as I said, when you use electronic forms especially, but in any case, it's really, really important to keep up to speed with all the deadlines involved. So I really recommend that you keep a copy of all the requests that you make, all the replies that come in, and you really mark what dates you received them and what dates you submitted them. And apart from that, I often, as soon as I do an access to documents request, I put in my calendar when I should expect to receive a reply, what would be the 15 working day deadline when it would expire. And if the institution extends that, then I then put that in my calendar, and that way I really keep track. Because the important thing to understand is that if an institution does not respond, then the deadline for your confirmatory application starts to run from when the response was due. So you really have to be on top of when that date is in case they don't respond. I've noted all of the deadlines, all of the relevant deadlines there. I'm not going to go through them all for you, but they're there for your reference if you need them. So then you've submitted your response, and a few different scenarios then can happen. Firstly, sometimes, it's pretty rare, but sometimes an institution simply doesn't respond. Or they respond and they have withheld some information. So in those situations, you have to decide whether you want to submit a confirmatory application. So when the institution simply doesn't respond, it's usually worth your while to do a confirmatory application, because if you don't, within the deadline, you will lose your right to do that. Quite often what happens is that you'll start drafting your confirmatory application, and then the commission will actually respond late. And then you have to kind of redraft your confirmatory application to take into account what the institution has actually said. But if you do receive an initial reply that withholds information, these are the kind of the questions to ask yourself in deciding whether you want to submit a confirmatory application. So first of all, is the information that's been withheld significant for your purpose? So an example of that is that I quite often get an initial response that blacks out all of the personal data from the documents that I receive. It's quite rare that I'm actually interested in the personal data, so I very rarely challenge a refusal on that basis. I just kind of let that go, because it's not important for me to have the information. Sometimes it is, and in that case, then I will challenge it. Secondly, you have to think: do you actually agree with the decision to withhold the information? It might happen that the initial refusal is so well argued and so well justified that you actually agree with it. Finally, but if you don't agree with it, and if the information is significant to you, then you really must go ahead and do that confirmatory application. The final reason why you might do one is that you are expecting information to be identified that's in the institution's possession, and actually it's the institution simply doesn't mention it basically in their reply. They don't justify why they're withholding it, and they don't give it to you. And there you can then ask for a confirmatory application, just to ask them to reconsider that, what documents that they hold come within the scope of your request. And that I just want to clarify that that's not usually out of bad faith on the part of the institution, but they're dealing with huge amounts of information. When you send a request, especially if it's quite an open request, it means that they have to check their document filing system. They have to ask the relevant officials if they have any emails, etc. And it's quite a big task. And sometimes, just through human error, they don't manage to identify all of the documents that are pertinent to a request. And therefore, you can really use the confirmatory application procedure to make sure that they've identified everything that would be relevant. So it's just I just want to clarify that if you get a refusal and you want to take it further to the Court of Justice of the EU or to the EU Ombudsman, you have to do a confirmatory application first. You don't have a choice. And if you don't do it, then you kind of you give up your right to challenge it further. So now turning to how to draft the confirmatory application. I've just put down here the kind of opening paragraph that we would usually use in our confirmatory application. So first of all, we make it clear what the legal basis of it is, Article 7.2 of Regulation 1049. We also make it really clear what Commission decision that we're applying for a kind of a reconsideration of. So the date of it, and usually we'll put in the reference that the institution has given, and then we reference back to what the information was that we requested, and then we clarify that we're really asking them to reconsider their decision. So there's I'm going to just give a few drafting suggestions for some very common arguments that you might want to put in a confirmatory application. I'm not going to, this isn't completely exhaustive, but just a few that come up very often. So the first one is the failure to state reasons. So in the Treaty on the Functioning of the European Union, Article 296 says very clearly that an EU institution has to justify and give reasons for its decisions, and sometimes they are lacking in replies to access to documents requests. So that's really the first thing that you can draw their attention to. That's certainly the case if you simply haven't received a reply to your request. That is automatically a failure to comply with Article 296 because it's an implied refusal with absolutely no reasoning whatsoever. However, if you have received a reply, this might still be relevant. So the Court of Justice has made it clear that that duty to state reasons in the context of access to documents requests means that an institution's reply must make it possible to understand and ascertain first whether the document requested falls within the sphere covered by the exception that was relied on to withhold the information, and secondly, whether that need for protection is genuine or not. So if you think that that reply to your request doesn't come up to this standard, this is some handy wording to provide, to put into your application. And there is just the kind of wording that I would use, or that we would use when we want the institution just to check that they've really identified all of the documents that they hold and that are relevant to your request. So that's just for your own reference later if that's useful. Finally, the most common ground for challenging a refusal to grant access to documents is because you think that the institutions have withheld information by using an exception that has been wrongly used, that doesn't apply to this case, or that hasn't been justified by the institutions. And there I'm going to refer you back to our last webinar of the 5th of December when we really went through how to tackle some of the most commonly used exceptions. So these are really the substantive legal arguments that you can put into your application. Finally, as you know, maybe from our previous webinars, for some of the exceptions in Regulation 1049, you, even if the exception applies, the institution has to disclose the information if there's an overriding public interest in disclosure. Again, I'm going to refer you back to our previous webinar, again from December 2019, where we discuss in much more detail kind of the substantive grounds for showing that there's an overriding public interest in disclosure. So I'm not going to go through them here, but just to say that if this is, the confirmatory application is really your opportunity to tell the institutions why they should disclose the information and why it's in the public interest to do so. And you should try and be as as expansive as you possibly can on that, because this is really your opportunity. So I'm going to pass you over to my Sebastian, my colleague Sebastian, to go through the next stage when you actually challenge the confirmatory decision either before the Court of Justice or before the Ombudsman.
Thank you, Anne, and hello everyone. So I will be speaking to you about the possibilities once you have received the confirmatory decision from the institution. So you have made a confirmation, so that's the mandatory first step, and then you have still not obtained the information either because the institution has refused it or simply failed to reply. In that case, you have two options. You can make a complaint to the EU Ombudsman, or you can bring a judicial challenge to the EU General Court. And so I will be speaking to you about both of them. But the first thing to consider is, of course, whether you want to bring a challenge. Should you bring a challenge? So some factors to consider. The first one is, of course, perhaps the most obvious one. What is the strength of the argument? Do you have actually arguments to make why the institution failed to comply with applicable procedures, made a grave procedural error, or just didn't comply with law, didn't comply with existing case law of the Court of Justice? So what is the likelihood of success of your challenge? And I speak about that a bit more in a moment as well. Once you feel you kind of have a case, another question to consider is, will the information that you want to have access to in fact be still relevant at the time that you could obtain it through the procedure? As I will mention in a moment, both procedures take time. If the information is basically already outdated at this stage, this might be a factor for you to say, well, we discontinue this at this stage. But it might not necessarily be the case, because the other aspect is there perhaps a broader impact of launching a challenge, this meaning going beyond just obtaining the specific piece of information? Is there perhaps a behavior that underlies the refusal that you would like to change behavior by the institution? Or is there perhaps does this present an opportunity to develop some important jurisprudence? And finally, a factor, of course, is the capacity investment of actually filing this, preparing the challenge, and for the continued exchanges then over the next years with the institution concerned and the costs involved. But yeah, first of all, just on the strength of the argument, to a large extent, this will depend on, of course, the case law of the court, the exceptions relied on, and as Anne already mentioned, we had some previous webinars that went through that in quite some detail. But perhaps there's some general categories of information that should be in principle accessible. Here are some examples of information that we often obtain. On the one hand, this is, for instance, lobbying communications, minutes that have been prepared of meetings. These can often be requested and are disclosed. Then we recently won a case in front of the Court of Justice that states that legislative impact assessment should be made public, or should be available on request at least before a proposal is published, which is seems to not be a practice yet, but it's a good request. Case files in front of the Court of Justice as soon as the case is closed, so as soon as judgment has been rendered, or otherwise the case has been discontinued. Then Anne already mentioned basic information on EU pilots and infringement procedures, not the case file where the procedure is ongoing, but which member states are involved, relevant dates, nature of the infringement, and then the infringement files once the case is closed. Generally evidence that the institutions have used in preparing their decisions, and finally drafts of a final version of plans or programs or similar documents that the member states submit to the institutions, usually to the Commission, to fulfill a legal requirement. Those should also be at least available on request. So this is, of course, not a 100% list. in the end of the day, it depends on the exceptions relied on, but I thought that perhaps this gives a bit of an indication in case you do not have so much experience with requesting information from the EU institutions. Then the other aspect that I already mentioned is the broader impact of your case, and here I thought it might be relevant for you to know what are some areas that we are working on, some areas that are currently contentious and where some case law development could help. For on the one hand, a very important fighting ground, so to say, is general presumptions of non-disclosure. Wherever the Commission has a tendency to try to establish new general presumptions of non-disclosure, and basically whenever this is done, it would be important that this is challenged. There is a list of general presumptions that have been accepted by the court. Those you can find in the case reference that I've provided there. But if the Commission is relying on a general presumption that's not in that list, this is, I think, something that's very important to challenge, to not have this category be expanded further. Another area is the definition of emissions into the environment. There has been some recent case law development on this, and we find that generally the institutions are applying this definition very narrowly, and so this is very important that this is further developed to change the practice. Another example is almost any use of the exception relating to internal decision making. This is Article 4.3 of the regulation 1049. This is because there the court has been very much in favor of disclosure, so has been very strict with the institutions. So this is, I think, generally an area where it's very good to bring appeals, bring court challenges, or go to the Ombudsman. Then access to member state positions, in particular in the context of the Council and the Council legislative procedure. This has been a political priority of the Ombudswoman Emily O'Reilly, who has just been re-elected. So we assume that might continue. And there has been some policy development on that, so that's a very interesting area. And then two other areas that we are working on is transparency of comitology procedures, which are, of course, famously opaque, and then information from the European Investment Bank on its financing operations, where we find that information is often lacking. And then finally, one aspect is the lack of active dissemination of information. So basically, the failure by the institutions to upload information on their website. Usually, this is something that's very difficult to challenge in front of the court, but is something that is perhaps worth to raise with the Ombudsman. So these are just some areas, but of course, this is not limited to this. Just to give you a bit of an idea about where there might be a broader impact, but generally speaking, every court case has the potential to develop further and help other applicants in the future with their access to information requests. Now, having spoken about this, just to give you a small introduction into the procedure, starting with the Court of Justice, the General Court, first of all. That is the deadline to file, I think Anne mentioned already, is 2 months plus 10 days on account of distance. So that means if you're not in Luxembourg, from the confirmatory decision or the absence of a decision. So the time by when the institution should have replied but did not. So this is quite a tight deadline, in particular because in this time you need to have a lawyer, so you need to arrange everything with your lawyer in that time. That lawyer needs to be independent in the sense based on the statute, so there's some case law on this that impacts NGOs quite a bit, because this means that the lawyer is sufficiently distant. So this means it can't be an employee of an organization, but it can also not be a chairman, a board member, a trustee, basically nobody that is in some way associated with your organization. So that's something to be very careful about and to keep in mind. Then the actual procedure, yes, they are written down the different stages, broadly an application and possibilities to respond for both parties, a hearing and then a judgment. This will take overall approximately 1.5 to 2 years, usually. Can be different, and then there's a possibility to appeal to the Court of Justice, and that will take about the same time. So that's quite a long timeline overall. If you're successful, the court will usually strike down the decision of the institution concerned, which will then issue a new decision and hopefully then grant you the information. One aspect that I want to talk about in the procedure of the Court of Justice is interventions. There is a possibility to intervene in cases that have been brought by another applicant, but you need to show an interest to intervene. So that would perhaps be that you're working on transparency in the issue, that you have another interest. Member states sometimes intervene as well in access to information cases. Sweden has an established track record of having intervened in some cases in favor of the applicant, in favor of greater transparency. On the other hand, effective member states, so member states from which the information originates, usually may intervene against disclosure, and the European Commission sometimes intervenes if the request concerns another institution, but the Commission finds that that information shouldn't be disclosed. And then there's a possibility for either the applicant or defendant to reply always to any interventions made. The option number 2, the European Ombudsman, the procedure is 2 years after the confirmatory decision or the implicit refusal, so that's a lot of time. That's a lot more relaxed. One thing that you can do is, because you have so much time, is you can combine a number of basically requests. So when you receive the number of negative confirmatory decision, you can bring that as one complaint to kind of raise a more systemic issue, a broader issue, as long as they have somewhat related to the same topic. The timeline is not as fixed. On the one hand, there's a fast track procedure that is quite good, because that means that the case should be resolved in 6 weeks. That's relatively new. But that should be the case if it's an access to information request that's relatively straightforward, and then the Ombudsman assumes that by the confirmatory decision the institution has already given its position, there won't be so much exchanges, so it won't be another opportunity for the institution to reply. So if that's the case, that can be quite a good option. If that's not the case, there will usually be a reply from the institution. There might be an inspection meeting organized, so this takes time. And then it might be resolved informally if the institution agrees, or if it doesn't agree, it might take longer. And then if there is a finding of maladministration and recommendations are issued, the institution always has another opportunity to reply of 3 months. So it makes it a bit difficult to tell how long it takes. And all of this, so both the rather unclear timeline and the rather open procedure, make it very important that you follow up actively with the desk officer that is assigned to the case whenever you do not hear anything anymore, if there's long delays, to also always insist on your right to reply to any documents that have been submitted, any observations by the institutions, and so on. So that's very important to keep in mind when dealing with the Ombudsman. So how do these options compare? The General Court has the advantages that it issues binding decisions. That's, of course, a very important advantage. You have the possibility to appeal to the Court of Justice if you're not satisfied with the decision. It doesn't exist from the Ombudsman, but there is a form of asking for reconsideration, but it's not the same level of reconsideration that you get from the Court of Justice. There's the advantage of the broader impact. It develops the case law. It provides binding interpretations of the law that can aid other applicants and you in the future. The disadvantage is it is rather slow, 1.5 to 2 years. That can also be the time in front of the Ombudsman, but then in particular, if there's an appeal, that adds another time the same amount, so that makes it quite long. There's the cost exposure. You need to hire a lawyer who you need to pay, and if you lose the case, you will be stuck with the costs. These will be reimbursed if you win the case. But in the loser pays principle applies, so that means you also have to carry the costs of the institutions if you lose. These costs are usually low, though. The Commission will represent itself usually and will not require a lot of funds. But that might be different for some of the agencies that sometimes seek external counsel. And there is the risk that we have not experienced yet, but that we have heard of, that if the information is commercial, relates to the workings of undertakings in specific sectors, that they might intervene, so that you might have a company intervening in the case, and that then you will have to pay the costs of that intervening party. That is, I think, the biggest cost risk, because that could be a quite high amount. But as I said, this is something we have not had personal experience with, and that should be rather rare, but it's still good to be aware of. Yeah, and finally, disadvantage. The procedural rules are strict. The scope of review of the court is very limited to legal violations, and that is, yeah, different to the Ombudsman, of course, who is a lot more open. So yeah, the Ombudsman, what are the advantages? It's free of charge. You have 2 years to file the case, which is quite relaxed. The Ombudsman will consider wider maladministration issues as part of the complaint, any kind of issues of non-compliance with procedures, and other aspects of the actions of the institution will be considered. You do not need a lawyer. And the Ombudsman has political priorities. Usually in the past this has been counter transparency, as we mentioned, and since Ms. O'Reilly has been re-elected just now, that might continue in the near future. So if your request relates to one of these political priorities, it might benefit from some special treatment in that it might be resolved a bit quicker and receive some additional publicity. Disadvantages, as I said, the timeline can be a bit unclear, but can also be quite quick. The non-binding decisions, that's the main disadvantage. It may be ignored. We had some Ombudsman decisions in the past, 2 or 3 relatively recent, that have been ignored or are being ignored by the institutions. We will, of course, continue to insist on them, but there's not a direct, immediate change in behavior. And the Ombudsman, or at least this Ombudsman, is rather hesitant to interpret the law. She doesn't see herself as a court. So if there is no pre-existing case law or jurisprudence on a specific issue, there's a general hesitance to provide too much of an own interpretation of what the law says on a specific point. So these are how the 2 options compare in advantages and disadvantages, just to illustrate that on some examples of cases that we have brought. On the one hand, court cases on impact assessment, confirmatory checking studies, identity of ESFA experts. I think all what these cases had in common is that we had a very clear understanding of what the law says, or like an interpretation of what the law says that differed from the institution, and that we wanted the court to rule on. And so we went to the court. While the Ombudsman decisions, when you look at them, we are often raising broader issues. Of course, can also be a capacity issue. It requires less capacity to go to the Ombudsman. But also you can raise broader issues. You can raise active dissemination. Here, for instance, active dissemination of Fisheries Council documents, which are difficult to raise in front of the court. So to require an institution to upload certain information proactively on their website. And then also you can bring cases that are not actually related to a specific request and a specific refusal. For instance, we had a case that concerned the transparency policy as a whole of the European Investment Bank. So it wasn't related to a specific refusal, but to the way this policy complied with the applicable legal requirements. So you can see a bit more the open nature of these requests that provide a bit of context for that decision. Then finally, I wanted to raise one special case. That's the delay tactic that kind of came up already a few times during this webinar. There may be the possibility that the institution just doesn't reply, at least to the confirmatory application, and just kind of waits and hopes it goes away, or hopes that by dragging its feet, it can just kind of hold out long enough that the requested information becomes irrelevant. For instance, because a decision-making procedure concludes. In these cases, it's very important to remember that the time limit runs from the deadline of reply for the institution. So you need to be very careful not to miss the deadline to apply to the court in particular. For the Ombudsman, you have a lot of time, so it's more unlikely to happen. And then, yeah, as soon as the information is disclosed by the institution, the court may find that there's no longer a cause of action. So that's something to know. In that cases, you can argue that you have a continuing interest in the proceedings. For instance, because there is a broader legal issue concerned. We had that in one of our cases where the Commission tried to establish a new general presumption of disclosure for impact assessment documents. Then it disclosed these documents actually to us once the procedure was concluded, but the court found that the case was still relevant because there was a broader issue that was likely to recur in the future. Yeah, and then what the court usually does in these cases, though, is it will issue an order, or that's what it has done in the past, and then usually award, though, the cost of the applicant. So that's just something to know in case that comes up, because it is a thing that we have encountered in the past, just to give you a bit of an idea what can happen in such a court proceeding. So this is, to conclude, just a few, I think, give you a few broader message that I think came through our webinar today. On the one hand, access to information requests are a very important tool. We are using them a lot, but we find they're still underused, at least in the public interest by environmental NGOs and individuals. Statistically, most requests are still filed by academics. So we have some catching up to do. The EU institutions will frequently refuse access to documents on the first instance. That can often be in violation of the legal requirements. First instance decisions are usually prepared with less effort. So it's often worth the effort to make at least a confirmatory application. It's also the case that confirmatory applications go to the Secretary General, so it's a different unit. Then for the first instance decision, they're treated more seriously. So there's really a potential to just through a confirmatory application get access to more information. And finally, court challenges and ombudsman decisions. It is important to also consider not only the impact in the specific case, but also the lasting impact beyond the case, the opportunity to change the behavior of the institution, develop the case law, which is really important and benefits the wider public interest, civil society community. So that's the conclusion. Use your rights or lose them, and be encouraged to do so. Now, this concludes our webinar of today. We will still have the opportunity for questions now in a moment. What I wanted to say before is there is a series of webinars coming up. The next series will be on the right to clean air and access to justice. So here are the sessions in January, February, and we will of course also inform you about that in due course. Now, if you have any questions, there is an opportunity to put them in writing to us. Just now on the left side you will find there's a Q&A button with a question mark, and you can go ahead and type away, and then we'll do our best to answer these questions. So here we already have one question from the Estonian Environmental Law Center, Karel. The first question is, what is the public interest for disclosing environmental information, and when can it be considered overriding, especially considering that one needs not to disclose the interest for requesting environmental information? That's the first question. On that one, I think the first important thing is that you do not need to state the interest of requesting environmental information. That's correct, and we do not do that in the beginning. But then once you file a confirmatory application, You are very much encouraged to do so if the information is refused. And then what is the public interest can really be anything why you want to have access to the information. So the court has unfortunately been very restrictive with this, and has said it needs to be a very special interest that is specific to the case. We've talked about that a little bit during the last webinar. The question is essentially, why do you want this information? Why is this particular information so important to you? Why is disclosure immediately necessary for you to do your work? And yes.
And why it's important to the public in general as well.
Yes, of course. Yeah, so it shouldn't be a private interest. So meaning to your work, I meant now in a sense because you seem to work for environmental organizations.
Yeah.
But yes, in the public interest. The second question. Minutes of a meeting may be quite abstract. Can one request personal notes made by participating officials? For instance, is it a document in the meaning of the regulation?
Yes. I think that the definition of a document is that it has to be within the possession of the institutions, and it has to be relevant to their work. So I think definitely the notes taken by an official who is present at a meeting would definitely come within that definition. Just to highlight that in the European Parliament, they have controversially their own definition of what a document is, and it doesn't include documents drawn up by the METs in their political capacity. I can't remember exactly how it's worded, but that's the only instance in which that kind of document would be withheld, probably by the Parliament. So
then we have two questions. On the one hand, on the possible risk of the cost from commercial interveners, if there's any risk of cost from member states who choose to intervene that you will have to pay?
No, I think it's quite clear in the rules of procedure that certainly interventions from member states and other EU institutions, they have to pay their own costs. But that rule doesn't apply to third-party interveners, and that's where the kind of danger comes for environmental NGOs. But as I said, that usually would only be a risk if you're accessing information that's very sensitive for them. So, for example, the case I'm thinking of was when Greenpeace requested access to some of the studies on glyphosate. So that was really then you had interveners from, the crop life, from Bayer, Monsanto, etc., because that information was really relevant to them. And in that case, Greenpeace and PAN, Pesticides Action Network, were ordered to pay their costs. Now, I don't know how that panned out in reality, what kind of, what they were actually ordered to pay in real terms. So I can't speak to that, but it's just definitely something to keep in mind.
Mm-hmm. Mm-hmm. Then there's a second question, but that relates to the criteria of the Court of Justice in relation to preliminary references under Article 267 TFU. On this one, do you have a thought on this? I think there's a bit of a mix-up here, because a preliminary reference under Article 267 would come from a national court or tribunal. So I think the European Ombudsman can't refer a question to the Court of Justice.
Are the criteria you clarified? Sorry, I'm just not sure what criteria you're talking about. Criteria in relation to what? So if you could clarify that, then I might be able to help. But I'm just not aware of what criteria you're talking about.
Mm-hmm.
Okay, the next question is about Brexit, my favourite. Is it right that UK citizens' organisations will lose their rights after Brexit, or do rights extend beyond EU citizens? The EU institutions don't. I think that Regulation 1049 does mention that it's a right for EU residents. I can't remember exactly, but they don't apply that. They really treat requests for access to documents coming from from anywhere. I think that's my. I don't think that British-based residents and organisations will lose those rights, but I might get back to you on that.
I mean, of course, other rights will be affected in relation to obtaining information from your national institutions, perhaps, because there's a directive on that will no longer apply.
Yeah.
But of course, if you try to obtain information from the EU institutions, that will still continue to be possible under the same conditions.
Really, my understanding is that the EU institutions treat all access to documents requests if they're from real people, and that's why they ask for people's postal address, is to verify that they're not from automatic, from, what do you call it, bots. So yeah, I don't think that's going to be a problem.
Then we have a question, could you give an example of the costs for a procedure in front of the General Court?
I think they are generally lower than €1,000 in a normal case. Usually it's just the travel expenses of the, so sorry, yeah, you didn't see that question yet. So that's someone asking about the,
No.
Oh, no, they could see. Okay. Sorry. So they're generally lower than €1,000, to my knowledge. Usually, in an ordinary case where an institution hasn't retained outside external counsel, then they only charge for the accommodation and travel costs to Luxembourg for the hearings and for photocopying costs. So it's generally really is quite low in comparison to other national cases.
Then the next question is whether we think there's a potential in the future for public participation obligations to be expanded to include greater access to raw data related to the environment, which is normally not disclosed due to business interests or copyright issues, for communities who make their own impact assessments, which require such information, and if this is worth pursuing with litigation. So it's a quite specific question. I think that we would need some more context to. One thing I can tell you is that in relation to raw data, there has been a finding of the Aarhus Convention Compliance Committee concerning the United Kingdom that has stated that raw data should be disclosed, and that if necessary, the institution should then indicate that this information is not in the final form, that it's not processed data. So that's just on the point of raw data. Whether that information, though, is covered by, for instance, an exception relating commercial and industrial information, is a much more complex question that will depend on very much what specific information is involved. On the general case law on that, I think we've covered a bit in the last webinars. And then on public participation obligations, it depends very much on the decision-making procedure, what kind of obligations there are. Right now, there's public participation obligations relating to specific activities that affect the environment, relate to plans and programs, and then less relate to policy and legislation, but there's always some development. This always depends a bit on the nature. So it will depend. I'm sorry.
Typical lawyer's answer. There you go. Okay, another question. Thank you for the presentation. I would like to ask about the court decisions regarding the currently contentious areas. Can you go further on the arguments of the court? I would really, if you didn't tune into our previous webinars, I would recommend that you listen to those, because there we really do cover in much more detail the reasoning of the court in relation to the access to documents right, the access to environmental information rights and the exceptions to those rights. So on our website and also on the first page of our presentation here, which you will have access to, there are links to those two webinars, and I would recommend reading those, listening to those. Okay.
Yes. Yeah, and we always also send a follow-up email after the webinar with all this kind of information, so you can look it up.
Okay. Beneficiaries in scope. Any citizens of the Union? Yes, indeed, that was someone who is, pointing out exactly what the regulation says, and in terms of who can request access to information. And it does say any citizen of the Union and any natural or legal persons residing or having its registered office in a member state has the right to access documents. I was aware that there is that limitation, but I'm pretty sure that that in practice is not the way that the member states actually deal with the requests coming from outside the union, but I can check for that. In
the case of environmental information, that would also not be compliant with the obligation of the EU under the Aarhus Convention. So that would be something to rely on in case this argument is ever raised by an institution. But yeah, I mean, I think as N, this should in practice usually not come up.
Okay. I think that's all our questions answered. So
okay. Yeah, thank you very much.
Yeah, thanks very much. And hopefully you'll tune into these other webinars on the right to clean air, which will be given to you by the clean air experts in ClientEarth.
Okay, thank you very much. Have a good day.